Hello everyone, this is Tom Fox and I would like to welcome you to episode 25 of the FCPA Compliance and Ethics blog. Today I wanted to visit with you about mergers and acquisitions under the FCPA. But before I do, I would like to announce a special offer for my two books that I've written on the FCPA. The first one is Lessons Learned on Compliance and Ethics. The second is Best Practices under the FCPA and UK Bribery Act. Both of these books are available on Amazon.com and they're $20 each. However, through the end of the year, I can sell both of them to you for a total of $20 plus $5 shipping. If you buy both of the books, I'll throw in a hardbound copy of my ebook, GSK in China, A Game Changer in Compliance. The trick is that you have to email me and send me a check because I don't have a PayPal account or a way to take your credit or debit card. So what you need to do is email me and then mail me a check, and I will send you both of those books. You can email me at tfox@tfoxlaw.com. I hope you take advantage of this offer. It'd be a good way for you to, if you haven't read my books, to catch up on what some of the best practices and some of the top thought practitioners in the country are saying about compliance programs. As you know, I try to be the nuts and bolts guy on compliance programs. How do you implement or enhance a compliance solution inside of a corporation? And I think these two books will give you some specific guidance on how to do that with your compliance program. Certainly, if you are doing business in China, GSK in China, A Game Changer in Compliance, my ebook, will give you some insights into what has happened with GSK and several other Western companies who've gotten into anti-corruption and anti-bribery hot water in China over the past 6 months. So shoot me an email and send me a check, or just send me a check and I'll send you the books. With that, I would like to turn to the subject of mergers and acquisitions under the FCPA. This is an area that has scared many companies here in the United States for fear of springing liability. Springing liability is usually thought of as buying a FCPA violation through the purchase or acquisition of a company which may not have been subject to FCPA jurisdiction in the past, but they are now. If you're a U.S. company and you're subject to the FCPA, if you buy a foreign company, they become subject to the FCPA. Many U.S. companies have feared that if they bought a company that had engaged in bribery and corruption in the past, they will somehow become liable. The Department of Justice has made clear that they will not prosecute companies based upon that action. Where the Department of Justice will prosecute U.S. companies is if they do not investigate or perform an adequate investigation into any acquired company, institute a best practices FCPA compliance program, perform a forensic audit, and turn over the results to the Department of Justice if they show bribery and corruption has occurred in the past. So I think the department has laid out a protocol that you need to put in place. Most companies were aware of their post-acquisition obligations under the FCPA because these have been set out in several deferred prosecution agreements over the past couple of years. DS&S, J&J, Pfizer, for instance, all had information and language relating to post-acquisition integration in the mergers and acquisition context. However, with the release of the FCPA guidance in November of last year, the department really, for the first time, and Securities and Exchange Commission, talked about the importance of pre-acquisition phase in your compliance program for M&A work. Number 10 of the 10 hallmarks of an effective compliance program specifically talked about mergers and acquisition, and obviously they divided it into pre-acquisition and post-acquisition. In the pre-acquisition phase, this was really the first time we'd heard the department talk about this, at least in a public manner. There had been a declination in the past given to a company who'd engaged in extensive pre-acquisition due diligence and then had remediated issues after they had acquired the company, but that was a declination and was not publicly released information, at least till the release of the FCPA guidance in November of 2012. But the department wants a company to engage in substantive pre-acquisition compliance protocol under the FCPA. This protocol all starts with a risk assessment. The guidance specifies that you need to assess the risk of any target you're looking at. The department recognizes that you will not have perfect information. You will not have the documents that you need to do a full-bore risk assessment. Nevertheless, the department suggests that there are various other areas that you can do research into. This research can be in market research. This research can be internet or other research. But the most important area that you could probably research is your own employee base. And I say this because your own employees are going to understand, if they're in the same or similar industry, what the compliance risks are for a target company. So that would be one place to start. But you also need to think about that risk assessment as your game plan for going forward. The department has made clear that many areas of your compliance program will start with a risk assessment, because that is a written document which will help you to develop a roadmap to remediate any problems that go forward. The department wants to see documentation on what you found, and more importantly, your thought process about how you're going to go forward. This all starts with a risk assessment. From there, you need to ask for certain categories of documents. Hopefully, you're in a jurisdiction where a large number of documents would be made available to you. In the compliance arena, you certainly need to start with a compliance program consisting of policies and procedures. You need to take a look at third-party representative due diligence files. You need to take a look at training that has given to your employee. If there are any outstanding violations, you certainly need to take a hard look at those. You also need to do transaction monitoring. By this I mean you need to take a look at the spend for third-party sales representatives, see if there are any anomalies. Take a look at employee spend. You're certainly the top level of producers within the company if they use an employee base for their sales model as opposed to third-party representatives. You also need to look at charitable donations to see if a protocol is in place for review of any request for charitable donation and that protocol is followed. From there, you need to interview many of the senior management of a target company. You certainly need to talk to the CEO and president, but also you need to talk to the chief financial officer, the chief compliance officer. If there's someone in accounts payable or accounting, you'll need to talk to them. You certainly need to talk to the general counsel. To the extent that employees will be made available to you, you need to talk to them about the overall attitude of the company towards compliance. It's important that you have an understanding of all of these factors because the department wants, I think, an independent assessment of a target's value from the compliance perspective. But it's important to you as a business person or a businessman as well, because for a couple of additional reasons. The first one is the value of the company. If a company has engaged in bribery and corruption as a part of their business model, the ongoing way that they do business, and they cannot do so in the future because they are a subsidiary or actually a part of a U.S. company subject to the FCPA, this is going to negatively impact their cash flow. It's going to negatively impact their overall business value to you. This is something that you need to assess. The second reason is, what are going to be the costs for you to remediate? If they're in a jurisdiction outside the United States, which we have to assume they are, how much is it going to cost you to do a full FCPA forensic audit, for instance? How much is it going to cost you to go train at a off-site locations? How much is it going to cost for you to implement FCPA appropriate internal controls, and what's that going to mean for the business going forward? In addition to the fact that they can no longer engage in bribery and corruption if that was part of their business model, simply putting in internal and financial controls could negatively impact the business as well. So these are all things you need to think about because it's going to be a part of your evaluation, but it's also going to be a part of a way for you to determine what are the costs going to be going forward. So this is all critical. You need to put a risk ranking for the company together, and this needs to be a part of your overall evaluation of the company. If you do acquire such a company, then you need to move to the post-acquisition phase. Many companies, I believe, are more knowledgeable about their post-acquisition obligations because the Department of Justice, starting with the Johnson & Johnson Deferred Prosecution Agreement in April 2011 and coming forward, has talked about post-acquisition integration as part of a best practices compliance program. The first thing you need to understand is the clock is ticking. By that I mean that there are certain things that you need to accomplish and get in place within a fairly specified time frame. The time frames we've seen the department put in deferred prosecution agreements are 12 months to complete a full FCPA forensic audit, 12 months to get the employee base, or at least the high-risk employees, trained live and in person, and 12 months to integrate your compliance program into the acquired company so that there's a seamless compliance program going forward. We've seen this extended out to 18 months in some deferred prosecution agreements, and now the language the department seems to have settled on is as soon as practicable. Nevertheless, if it's much past 18 months, certainly past 24 months, I think this is something the department will not look favorably upon, and will find that foot dragging on your part would be a lack of commitment to the overall compliance process going forward. So what do you need to do post-acquisition? The first thing you need to do is, now that you have control of the books and records, you need to go in and do a full FCPA compliance forensic audit. This means on a worldwide basis. You're going to need to take a look at the transactions that third-party representatives have engaged in to see if there are any anomalies regarding the amounts of commissions paid and that sort of thing. You're going to need to get some powerful transaction monitoring software, some of which we visited about previously on this podcast. You're also going to need to have forensic auditors do a deep dive into the numbers even after you've done transaction monitoring. So you need to be prepared to have a accounting firm who can come in and lay a lot of bodies on a lot of numbers to do a full forensic analysis. You need to look at all of the due diligence files on the third-party representatives on the sales side, and you need to look at the third-party representatives on the supply chain side that may have government touch points: freight forwarders, visa processors, custom brokers, law firms, accounting firms, tax professionals, tax accountants, anyone that gets licenses or permits for you. That's certainly someone who may come into a company on the supply chain side as opposed to the sales side. But all of those files need to be reviewed, and the numbers need to be run and audited to determine if there's any bribery and corruption going on. You'll need to identify the high-risk employees, obviously senior management that sticks around, senior salespeople, top salespeople. If you're in certain high-risk regions or high-risk industries, there needs to be live and in-person training. Once again, with a 12 to 18-month time frame, this is in the corporate world, this is a tight time frame. So you need to have a plan in place to hit the ground running when you start. But lastly, and most importantly, is the integration of your compliance program into the new company if they stand alone as a subsidiary, or if they come into your company as an integrated part of your company, doing away with any independent corporate status. They'll need to seamlessly come into your compliance program. I mentioned that if this company does not have U.S. best practices internal controls or U.S. best practices financial controls, this can be quite a difficult and time-consuming process. For instance, if they're not on SAP, even if they're on Oracle or some other database, all of that needs to be integrated together on your overall ERP system. But if they're outside the United States, they may be using some other type of ERP system, or they may be using spreadsheets. So this is something that it's going to take some time, and you need to have some resources to be able to deliver to integrate this in. After you've done all of these, then you need to move forward and make an assessment to see if there's any conduct that the company did engage in or is still engaging in which violates the Foreign Corrupt Practices Act. If they are continuing to engage in conduct which violates the FCPA, you absolutely positively have to stop that conduct. And then to the extent, whatever extent you need to do so, you need to remediate that conduct. And by remediate that conduct, I mean not only stop it, but fix the problems that led to it. If that's internal controls, if that's terminating employees, if it's terminating sales representatives, representatives on the sales side, whatever it is, that conduct has to stop. Now you need to move to the final part, which is to disclose to the U.S. government, the Department of Justice, any FCPA violations that you have found. Obviously, when you disclose to the DOJ, they're going to ask a series of questions, and it may end up with a dreaded "where else" question. What that means is that you need to have fully complied with Hallmark number 10 in a best practices compliance program, both on the pre-acquisition side and the post-acquisition side. If you've done so, I'm confident the department will look favorably upon your efforts. But if you have failed to do so, the department, as with every time that you self-disclose, the department may look into other areas. And this may cause you some grief. It will certainly cause you some time, trouble, and effort. But if you've taken the steps that I've outlined, I think that you'll be in good shape. So once again, you need to think about your pre-acquisition compliance protocols to make sure that you have internally adequate resources, both in terms of personnel and money to spend to do the adequate due diligence that you need to do. Make an assessment of where a company is with their compliance program. Use that to evaluate the company from a compliance perspective for financial reasons, both in terms of valuation and in terms of how much it's going to cost to remediate any of these problems. When you, after you acquire a company, the clock is ticking. So you need to have your plan in place. You need to begin the implementation of that plan, because 18 months, as I said, is really not that long in the corporate world, particularly when you're doing other things. So a post-acquisition integration, a full forensic FCPA audit, training, and then disclosure, if necessary, are all key components. One thing that I do need to add to all of this discussion is the opinion release 0802, which is typically referred to as the Halliburton opinion release. This opinion release came about because Halliburton was trying to acquire a UK company called Expro. For legal reasons, Halliburton was not able to take a very detailed pre-acquisition look at books and records, so they were somewhat stymied in their ability to know what they were getting into in terms, or at least from the compliance perspective. They proposed a very tight set of time frames to the Department of Justice after they acquired the company. It turned out they didn't, but had they acquired the company, under which they would do the following. They would divide the third-party business representatives of Expro into high risk, medium risk, and low risk. And within 90 days, it would perform a full risk assessment, forensic audit, and evaluation of high risk business representatives, 120 days for medium risk, and 180 days for low risk. After each of these time frames, they would write up reports and disclose to the government if they found any violations. If you've ever been in the corporate world, you know 90 days is almost next to nothing. And to get out and perform a forensic audit and do a risk assessment and also a compliance audit is a very tall order. But Halliburton had to do so because they could not look at any of the substantive documents prior to acquisition. I think the department recognizes the difficulty a company has in doing that. Nevertheless, it's important to the department that if you do not engage in the pre-acquisition steps that I've outlined and are specified in the FCPA guidance, they're going to put a very tight time frame on you post-acquisition. So this is something that you need to consider in any acquisition that you make. Obviously, the Halliburton opinion release was specific to those facts. Nevertheless, if you are in the situation that Halliburton found itself, cannot engage in adequate pre-acquisition due diligence, there is a remedy for you in the form of this opinion release, and if you follow it, I think the department will certainly look favorably upon that. I want to end by emphasizing that companies need not fear mergers and acquisitions under the FCPA. The steps to protect yourself, I think, are laid out in the guidance and the various deferred prosecution agreements and the Halliburton opinion release that I've mentioned. I would commend to you to read these, and I'm certainly willing to share any of these that I have with you if you need further information. So I'd like to end by once again giving my email. It's tfox@tfoxlaw.com. If you have any questions on any of the things I've talked about in today's podcast, I hope you'll contact me, and I thank you for watching and or listening. Thank you very much.